Write a brief note on the importance of the law of evidence. It is said that the law of evidence is the Lex Fori. What does it mean? The law of evidence occupies a very important place in the administration of justice. It forms the basis upon which courts determine the truth or falsify of disputed facts. Without evidence, courts cannot properly decide rights, duties, liabilities, or obligations of the parties. Therefore, evidence is considered the foundation stone of the entire judicial system. The administration of justice depends not only on legal principles but also on proof of facts. Whenever a dispute comes before a court, the parties present facts and claims in support of their case. The court cannot decide the matter merely on assumptions, suspicions, or arguments. It requires reliable proof in the form of evidence. Therefore, evidence may be defined as all legal means except mere arguments which help in proving or disproving a fact before a court of law. The importance of the law of evidence lies in the fact that it provides rules regarding what facts can be proved before the court, what facts cannot be proved, what type of evidence may be used, how evidence should be presented, who has the burden of proving a fact, the value and effect of different kinds of evidence. Without such rules, courts would face confusion and injustice because unreliable or irrelevant material could influence judicial decisions. Importance of law of evidence. The importance of the law of evidence can be understood in the following ways. First, helps in discovering truth. The main object of evidence law is to help the court discover the truth by admitting relevant evidence and excluding irrelevant matters. Second, ensures fair administration of justice. The law of evidence creates uniform rules for all cases and ensures that every person receives fair treatment before the law. Third, prevents false and fabricated claims. Evidence rules prevent parties from making false allegations or presenting unreliable material before the court. Fourth, protects rights of individuals. It protects the legal rights of persons by requiring proper proof before a decision is made. Fifth, help courts reach correct decisions. Judges rely on evidence for deciding cases. Proper evidence leads to proper judgments. Kinds of evidence. Different kinds of evidence recognized in law include first, oral evidence, statements made by witnesses before the court. Example, a witness personally tells the court what he saw. Second, documentary evidence, documents produced before the court for examination. For example, agreements, contracts, letters, certificates, records, etc. Third, conclusive evidence, evidence that the court must accept as complete proof and which generally excludes contrary evidence. Fourth, direct evidence, evidence of facts actually perceived by a witness through his own senses. For example, a witness sees a person committing theft. Fifth, circumstantial evidence. Evidence of fact not directly in issue but connected with the facts in issue. For example, fingerprints found at the scene of a crime. Sixth, real evidence. Material objects produced before the court, for example, weapons, blood-stained clothes, fingerprints, etc. Seventh, extrinsic evidence. Oral evidence given in relation to written documents. Eighth, hearsay evidence. Evidence of facts not personally seen or heard by a witness but learned from another person. For example, A says, B told me that she committed murder. Ninth, indirect evidence, circumstantial or hearsay evidence are called indirect evidence. Tenth, original evidence. Evidence having independent value of its own. 11th, derivative evidence. Evidence derived from another source. 12th, parole evidence. Oral evidence relating to written matters. 13th, prima facie evidence. Evidence sufficient to establish a fact unless disproved. 14th, primary evidence, the best available evidence itself, for example, original documents. 15th, secondary evidence, evidence given in place of primary evidence, for example, copies of documents. Definition given by Sir James Stephen. According to Sir James Stephen, the law of evidence is that part of procedural law which determines what facts may or may not be proved, what type of evidence should be given, and by whom and in what manner such evidence should be produced. The California Code of Civil Procedure also describes the law of evidence as a collection of general rules established by law. First, to determine what facts need not be proved. Second, to determine presumptions of law. Third, to regulate production of legal evidence. Fourth, to exclude illegal evidence. Fifth, to determine the value and fact of evidence. Law of evidence as Lex Fori. The term Lex Fori is a Latin expression which means law of the forum or law of the court where the case is tried. In simple words, it means that matters relating to procedure and evidence are governed by the law of the place where the court is situated and not by the law of the place where the cause of action arose. Evidence law is regarded as lexiphory because procedural matters are always governed by the law of the court conducting the trial. Illustration. Suppose A and B marry in India and later settle in England. A files a divorce against B in an English court. Although the marriage took place in India, the rules relating to evidence in that case will not be governed by Indian law. The court will apply English evidence law because the case is being tried in England. Thus, the law relating to evidence follows the principle of lex fori, meaning that the law of the court where the proceedings are taking place will apply. In Bain versus Whitehaven, Lord Brougham observed whether a witness is competent or not is to be determined by the law of the country where the remedy is sought and where the court sits. Conclusion. Thus, the law of evidence is extremely important because it forms the basis of judicial decision and ensures justice by providing rules for proving facts before courts. It is called lex fori because the law of evidence applicable in a case is generally the law of the country or court where the proceedings are conducted.